Yes, Mr. Clayton.
Good morning, my lords.
Good morning.
In this case, I appear together with Mr. Logan, Mr. Patterson, and Mr. Samal, two of whom have come from Trinidad to join us, and two of us are domestic. And against that, Mr. Just was ranged against us. Can I begin with two apologies? The first is that your lordship may have noticed, since we're using the electronic bundles, that some of the copies are less than clear. And the one important document we've handed up, and I'll come back to that. It's in fact document 59. It's the announcement of the adoption, if I can put it like that. And the second point, which I express as a note of caution, is that I'm afraid for my part, I don't have extensive experience working from electronic bundles, so I may not be as deft as some others are. So can I get my apology?
I'm so glad to hear that.
I find it, well, the thing about this, as I've discovered, is it works perfectly when it works.
Yeah.
But when it goes wrong, as it did when I was working on it yesterday, it's a catastrophe. So it divided into two bits, and I couldn't.
Well, Lord Wilson's joy is mirrored by my dismay.
I'm neutral.
Well, I found it a learning experience, which is always very exciting. My lords, we've handed up really three documents. The first, which I'll come back to very shortly actually, is really the one important document in the case, document 63, which is the adoption of the 2006 examination results. And the two other cases
I thought that was 61, actually, Mr. Clayton.
It's got a variety of numbers, Mr. Clayton. Don't worry too much.
I'm also slightly concerned about that.
It's 59 in some.
It is 59.
And is this the document that says 33 at the top?
Yes, it is. It is. I seem to discover that I think the electronic bundles may be differently numbered than
Anyway, you say it's the only important document in the case.
as far as I can see.
That's a relief.
Subject to be corrected. And then...
I tried to read 58 and 59 as well, which is a letter, the date of which I cannot tell you, Mr. Clayton, but you will know, from the Service Commissions Department to somebody or other. You've got 58 and 59 there?
Try the 17th of January.
Yeah, I'm afraid... Well, I'm pretty sure I'm right that really the only important document is the one I've handed up, because that is...
You've handed up this?
That one.
I'm talking about something different.
No, I know, but I'm afraid...
Oh, I see.
I'm a bit defeated by...
It's upside down.
Well, that's page 59, isn't it?
Yeah, I mean, I did have it at one point. I mean, we can make copies if it helps.
Mr. Clayton, if you say it's irrelevant, we'll take it from you.
Thank you very much. The other thing, what you also have is two copies, well, it's actually one judgment. It's the Court of Appeal decision in Cooper, or Cooper and Barbosa, as Mr. Ramlogan likes to call it. And he is going to refer to it because it's relevant in terms of some of the submissions rejected by the board and the way it was dealt with by the Court of Appeal in this case, as I understand it. Well, that said, can I move swiftly to the case? The sole issue, as is made clear from the Statement of Facts and Issues, page 260 of the bundle, is whether the use made of the 2006 examination results contravene the principle of independence of the Service Commission under the Constitution. And our case is that the appellant's complaint is that in substance, the promotion was decided by the minister by purporting to retrospectively adopt the results of the 2006 examination and utilizing the Regulation 14 procedure, which we will look at shortly, which actually expressly indicates that the process is appointed by a minister. Sorry.
What are the consequences of, if you're right?
Well, in Cooper, a declaration was granted that it was unlawful and contrary to the Constitution, so that...
Well, I'm not sure. Can we ask what you're asking for here?
A declaration.
Of what?
It's simply a declaration that the process is unlawful, because the difficulty in this case, as your lordships will see, it's a very old case.
The process adopted in 2006?
Yeah.
With what consequences for your client?
2006.
2007.
Well, 7 or 8.
Yeah, sorry, it's 2007, you're right.
December 2007.
I think that my client would hope that, fortified by the declaration, he would be treated differently. I mean, the difficulty, to be candid, is that it's so long ago that...
Well, I know, but that's why I want to know because the other point is, if your submission is that Regulation 14 is ultra vires, or ultra vires the Constitution.
Yes, it is.
Well, does that mean that all appointments made under that regulation are also retrospectively invalid back to 1998 or whatever it was? I mean, it may be the consequence, but we need to know what the consequence.
Well, I think I'd make this point, really. We're not seeking a quashing order, in effect. We're seeking a declaration, so it wouldn't necessarily have the draconian sanction. I mean,
You know what the terms of the declaration that you like are, really, wouldn't we, Mr.
Yeah.
Clay?
Yes, we would. Well, it may be that we can deal with that slightly further on. I mean, but I'm happy to try to do that. No, I mean, the
Should the
declaration...
declaration say, but the order is not quashed?
Yes, well, but normally a declaration gives an option to a public authority, and obviously the difficulty with this case is it's taken a very long time to get to the board for some reason.
If you want a declaration that something that happened in 2007 is unlawful,
Exactly.
you need to face up to what follows from that.
Well,
But you probably wouldn't want the declaration to go on to say, but the order or the original decision is not quashed.
yeah, we certainly wouldn't.
But Mr. Clayton,
I'm so sorry.
Mr. Clayton, if you got a declaration that the 2007 adoption was unlawful,
Yes.
why would it not follow that every promotion made and refusal of promotion articulated from 1998, referable to the Fire Service Examination Board exams, were not equally unlawful?
Well, I suppose that would be true in principle, subject to the fact that there would be huge delays in anyone acting on it, and whether in reality a court would accede to a complaint save of a 1998 candidate. I mean, I think that's probably the sense.
I mean, one thing he's not going to get is the promotion, is he?
No, he's not. No, he's not. But I mean, all of that is. I mean, at the end of the day, one's stuck by the fact that.
One understands sort of amour propre about the whole thing, but one does wonder what the purpose of it all is.
Well, one of the purposes might be, because we've been just discussing this, is it may be that this is really a point that Mr. Ramlogan is going to address here, because it involves a local. There have been sort of refinements of the Cooper principle since then, and there are obvious difficulties with the breadth of the exception carved out by Lord Hope in the Cooper case.
Do we have the terms of the declaration which were actually granted there?
Yes, we do. It actually appears in the last page of the opinion.
Well, I mean, he says what he's going to do.
Yeah. Oh, yes.
I find it quite a little difficult to follow. That's why I'd be interested to see.
Oh, I see. I'm afraid no.
I'm sure you must have it somewhere in this building. So.
Yes, probably that's true. But we don't have it. We just have the actual. But I mean, perhaps I'm.
Anyway, perhaps we can move on with this. We'll hear what Mr. Just says.
Sure.
But personally, I am very interested to know what you say are the consequences.
Right. Well, as I say, I perfectly understand that, and I think one of the difficulties is that I'm handicapped by the fact this case hasn't proceeded with enormous speed through the court. So,
Let's try to mitigate that by proceeding with some speed now.
Well, I'm happy to take that indication, if I may. Our principal submissions are that our case is building on the principles developed in Thomas and Cooper, two separate Privy Board cases. I'll come back to those shortly. The relevant facts can be really very shortly expressed. On the 6th of July of 2006, the board gave its opinion in Cooper. On the 10th and 11th In October, November of 2006, the appellant was a candidate in examinations which were under the Rule 14 procedure. And then on the 14th of December of 2007, the Public Service Commission, the first respondent, reconstituted the second respondent, the Public Service Examination Board, and delegated to the second respondent responsibility for the exams in future, which was really subject to any refinements by the board. Today, or in its opinion in due course, was really adopting the suggestion of Lord Hope in Cooper. And then the objectional part in our submission is the second part of their, or second decision they read, was to adopt the examination results in 2006 under the Regulation 14 procedure. And can I just invite you to turn up the one key document, as it seems to us, which you'll see, it's very terse, and I'll have additional brief submissions to make about the nature of the evidence before the court. But you'll see that it's dated the 21st of January, and the title indicates adoption of results. And you'll see then in the second paragraph, unfortunately with a date stamp, which obscured completely the word in the original thing, the word adopted appears again. And then the last paragraph says, subsequently, the Public Service Commission noted that the above-mentioned results and decided that the Chief Fire Officer should be informed that the Selection Board appointed to interview the candidates for the above-mentioned offices shall include a representative of the Service Commission Department. So you'll see that that's the position which obtains, that relates to the appellant. It may be of assistance, and this is my first go at the computer, if we look at the Constitution for a moment. Can I invite you to, I hope that this is right, to turn to page 528 of the bundle.
Yes?
I'm afraid I have to scroll down.
What is it, section 75?
Section 121 I wanted
21.
to take you to.
Yep.
Section 120 is about a public service commission, and as you'll see, these are autonomous organizations which have an important constitutional status in Trinidad. Subject to the provisions of the Constitution, the power to appoint persons to hold or act in office includes the power to make appointments on promotion. That's section 121(1). And then turning page, I want to take you to subsection 7. Sorry, this is at 529. Do say if I'm going...
No, go on.
Right. Okay, section 7 says, subsection 7 says, this section applies to all public offices, including, and it includes the fire service.
So the effect of that is it, that the Public Service Commission has the power to appoint fire service officers.
Exactly so.
Got it.
And the vice of which we complain is in substance.
Right.
And then if we turn to, just briefly, to the parallel regulations that apply to the police, which were the subject of the board's decision in Cooper, section 122, which is at page 530, subsection 1 creates the Police Service Commission, and then section 123, which is a little bit further on, that's at page 531 of the bundle. Subsection 1B, the Police Service Commission shall have the power to make appointments on promotion. So you can see there that in both instances the power of promotion lies on the commissions. Let's turn briefly to the regulations, if I may. Beginning with the fire service regulations, which are the ones pertinent to us, which is 562. If you just give me a moment to, I need to get there myself. Yes, Regulation 14 is important by way of its contrast to the one that applies to the police service, which I'll come back to. But you'll see that Regulation 14.1 expressly states that the examination board is appointed in writing by the minister. And under 1A, that board sets and conducts at least once a year an exam.
Well, the next word's important, which is to be passed by an officer prior to appointment.
Yes.
So they have a specific requirement before appointment.
The specific requirement is in Regulation 6, isn't it?
Well, there are a range of mandatory requirements, in truth. I mean, may I just ask you just to turn it? Sub 2 is important. Subsection 3 is important because it places people in an order of merit, which is obviously relevant for the selection of prospective candidates.
Mr. Clayton, if you pass the exam, do you get appointment, or are you only a candidate for appointment under Regulation 6?
Well, I'm told that in reality you get the appointment, although there are other processes. So I think it's a decisive factor, is the best.
But Regulation 6 is significant, isn't it? Because that tells you how the exam fits into the process.
Yes. It is significant, but the point I would
So you
make...
have, it's a precondition that you've got through an exam made by this particular board appointed by the minister.
Precisely so. So it's, in fact, in a sense, it's a kind of mandatory requirement that must be fulfilled. It's a precondition, as my Lord Conway rightly points out. Can I just point to the contrast with the police regulations? Because the submission I'm going to make in a minute is that, in reality, our case is stronger than the case that the board considered in Cooper. And I do that by going to 541(19). Now, before inviting you to read it, because I'm just going to invite you to read the whole regulation, I really want to make this point and this point only. Regulation 19, which deals with the police, is quite prescriptive in character and probably more prescriptive than Regulation 14. But the one thing it doesn't do is appoint a minister or anyone else. And in fact, the board decided by implication that was the procedure. So the contrast I'm drawing between the Cooper case and the Thomas case is in relation to the fire service. There's an express role for the minister, whereas the board decided in Cooper, as a matter of construction of the regulations in the context of the Constitution, that was impliedly the result.
Well, what difference does that make?
Well, to the extent it makes this difference is that, as I say, on the facts, looking at the relevant legal regimes, our case is a stronger indicator that something...
No, it's the same.
Yeah, isn't it? Surely,
You're implying a term.
Yeah.
Well, there's no difference between implying the term and having an express term. There's a term on either basis.
Well, as in so many things, it all depends on you. I accept the force of that. I'm simply saying it's a slightly more egregious situation because here in the situation of the... It's also maybe relevant...
Arguably, it's more egregious to imply it rather than be upfront and express it. But, I mean, I don't really think that this is going to be pivotal to your case, is it?
No, save this. It does indicate that the Regulation 14 itself is ultra vires because of the express reference to the minister.
Well, we better have a look at that, because don't forget, in Cooper, the point wasn't so much the method of appointment of the examinations board as the fact that the commission had, until corrected, declared itself incompetent.
I accept that, but I would say, in substance, they come to the same thing.
Can we see, I mean, what are you referring to us in these police regulations?
Well, the reason I'm referring to...
What are we looking at? I'm still trying to find where we're looking.
Sorry, I was looking at Regulation 19. This was the regulation which the
Yes.
board expressly considered in the Cooper case, and which they held to be, by implication, in breach of the separation of powers, because, as my Lord Hughes said,
19 is not dealing with the exam board.
it's the principles of selection for promotion.
There is an exam, 19.5.
Yes, thank you. And also,
Yeah.
or, as I said, it's slightly more prescriptive than...
Yes, but what does it say about the establishment of the examination board? Is there any equivalent of
No,
regulation?
it says nothing about it,
Yeah.
which is why the board and Cooper were driven to look at the constitutional setting. And that's why...
What you don't have here is a specific regulation which says that you've got to have an examination board established by the minister, which you have to pass in order to qualify.
Exactly. That's why I said there was a difference.
Yeah,
But
I understand that.
yeah, and so I think you know the way
Yeah.
where I put it. I can move on, I think. Can I next take you to the Thomas case, because there are passages in that which bear on this case. Thomas and the Attorney General. And what I particularly want to draw out of this case is the fact that it's the territory we're in is the principle of separation of powers, not the Cartona principle or Begbie and legitimate expectations or anything else. Can I just invite you to read the head note? The essence of this is a police officer was...
Sorry, where is that?
It's,
Oh, so sorry, 308,
308.
I hope. 308 in the electronic.
it is certainly 308 in the electronic one.
It's 2 in the agreed bundle.
We need to read all of the head note?
Well, it won't take very, I wasn't going to read it out. I was just
No,
gonna-
don't do that under any circumstances.
I was just going, it's just so that we know where we are. I'm going to take you to just...
Why don't you tell us in one sentence the point?
The point of it was that a police officer was charged with disciplinary offences, and he was removed effectively on the basis that the cabinet process was involved in it. I mean, actually, it's a final holding
Yeah.
on page 309, or the page following the first one. The removal of the plaintiff from the police service and the exercise of the Commission's disciplinary control over him fell fairly and squarely within the Commission's function and the jurisdiction conferred by Section 99 of the 1962 Constitution. That was the Constitution before Trinidad became a republic, and it parallels where we are now. And what I really wanted to take you to, which is the expression is Lord Diplock's approach to this principle of separation of powers, is at 314. And if I could ask you to turn that up, please.
Which internal page is that, please, Mr. Clayton?
Can you just give me a moment
I
to...
haven't got some of your notes.
21.
Thank you.
Sorry. Now, what I'd ask you to do is to read, if you would, please, from the paragraph beginning just above C, the right of the Crown to dismiss its servants at pleasure.
To speak of the right of the Crown.
Yes, please.
Right.
All the way to 3115.
That's 381 at the top and probably 21 electronically.
And then to read over the page, I think it is. Just give me a moment, because I'm... just over the page.
What page are we on?
We're on internal page 381, 382.
No,
They are there.
And you can see from that, well, I'll let you read it if I may, and then make the submission.
Yes.
And the fundamental point made by Lord Diplock really appears at J on this page, second line. The purpose of the Constitution is to insulate members of the commissions from political influence exercised directly upon them by the government of the day. So that's the principle in play, if I can put it like that. And you can see from the top of page 382, it includes the power to make appointments, the first sentence of 382, the power to make appointments to the relevant service. And then if I could ask you to turn to...
It's odd, isn't it, that the claimant in that case had, I think, been dismissed by the Commission.
Yes.
His complaint was that he ought to have been dismissed by the Governor-General. Is that right?
I think that is right.
Anyway, never mind. The principle comes out of it anyway.
Exactly so.
Okay.
I could ask you to turn to what should be page 317.
So what is this document, Mr. Clayton?
This is it's the same judgment.
Oh, I see.
So sorry.
Internal?
Internal 3. So sorry.
284. 384.
Get the whole page and be able to read it. 384.
Thank you.
So where we are is there's a what's happening here is that Mr. Digimans, as he then was making a submission, and it was rejected by their lordships, and you pick it up at J, and it describes the whole purpose of the Constitution, which it's already described, i.e. separation of powers, and it also raises the suggestion that there are issues about the conflict of human rights entrenched by the Constitution, the right of an individual to equality of treatment from any public authority in the exercise of its function. Dismissal of an individual of a public service by whim is a negation of the equality of treatment. So it simply underlines the force, if I may say so, of the separation of powers principle and the way that plays out in the context of some of the fundamental rights guaranteed by the Trinidad Constitution. So having, I hope, explained why we contend that the separation of powers is really the crucial principle in play, I now want to turn to Cooper, which is on the authority before in the bundle, and it's not for some reason, it's the authority before, it's 296 of the electronic bundle.
Yes.
And can I ask, I mean, obviously this case is central to this.
It's set out in extenso in the cases, isn't it?
It is, and it may therefore not be necessary to read out huge chunks of it. But can I take you to the passages which, in our submission...
Well, you can take it that we've all read the case very carefully and therefore are very familiar with the passages on which I think you intend to rely.
Well, can I just... I'm so sorry. I'm afraid I actually find it slower, for which I apologise, using the electronic bundle. Can I just...
What about simply taking your case and referring to the bits?
Well, what I was hoping to do was just look at the bits I've marked up, just to see if there are any passages that I've... Contrary to what some people assume, it's actually harder working from electronic bundles than one might assume.
It is until you get used to it.
That was why I was suggesting that you look at your case, where you no doubt set out the relevant bits.
Well, before you... Can I...
Certainly do that. Well, can I do that first of all, and then just...
Do you have it in hard copy form?
No, because I haven't marked it all twice. It was difficult enough to do it on the computer, which for those of us less literate than some was not an easy task.
Let's...
Okay, so what I want to look at is I referred in the printed case, page 4 of the printed case, to paragraph 21.
Sorry to be difficult, but the regulation 19, which is referred to in paragraph 14 of Cooper, is not the same as the regulation 19, which you showed us a moment ago. I suspect the regulations we've got in the bundle are not the relevant ones. The relevant regulation, the corresponding regulation is regulation 50, but I don't think it's the same one.
Oh,
So, I mean, don't worry now, maybe one of your juniors can have a look at that.
Sort that out, because there is one set of regulations extant, but,
Yes.
which is undated, unhelpfully.
I
so-
suspect it's a different set, because the Regulation 19, which is the one which deals with examinations, is set out paragraph 14.
Can I just look at that, if I may, just to deal with that point now that Lord Conway has raised it, and you'll just have to bear with me because the computer's frozen. Frozen. I'm so sorry.
Shall I lend you a hard copy? I've got 2 hard copies.
May I? Because
I think it may be easier, because I think
yeah, it's just I'm afraid my copy's just frozen for some reason. So 14.
106.
Yes. Well, I'm grateful to my Lord Conworth, for the regulation. Sorry, I diverted you down a wrong route, as it transpires. But you can see that I think the point remains about the express implied point, the significance of which.
there's undoubtedly a difference
Yeah.
between those regulations and our regulations.
Yeah, exactly.
Thus, I would quite like to see the regulation. I mean, it may not be achievable, but I would have quite liked to have seen the regulations which were an issue in this
Yeah,
case.
I mean, we've tried, and I think what's happened is it's.
Anyway, I mean, the answers, they're not the ones that appear at page 541 of our bundle.
And the curiosity of the ones that do appear is they are undated, which is unusual for.
They also talk about someone called the Commissioner, and I was going to ask you who he was, but it may not matter.
No, it may not matter. I mean, I can only apologise, but say obviously, as my Lord Conworth points out, the board was concerned with the document.
And we've got the right. You can hang on to that if it helps.
Thank you. I'm just going to have another go to see if this. It's locked. Can I just ask your indulgence to close this and open it, please? Just because
What's wrong with just referring to your extracts in your case?
because I think I may have found something else, which I'm afraid I don't have immediate recall of everything I've read. I promise I won't be very long.
2 minutes.
I just have to.
Your computer is frozen, is it, Mr. Clayton?
Well, no, I'm just reopened it now. So it should be much faster.
You don't need a little time to reboot it?
No. It's just the bundle froze for some reason.
Okay.
I can only apologise. It's quite a good computer, so I don't know why it's decided to do this to me.
John Wilson is enjoying himself enormously.
Well, it proves that these things don't work perfectly. Now, can I just quickly go through what I've highlighted? Because when I re-looked at this again, I think there were other passages which might be germane. And I'm just racing through this now, so I've now got to paragraph 14. Well, 21, which I've already taken you to, the passage, that's paragraph 21, which says the Constitution must be read as a whole, and then the passage from Thomas, which I referred to earlier from Lord Diplock, and then the question is whether, and if so, to what extent the appointment conflicts with the guidance in Thomas. And then Lord Hope asks where is the line to be drawn. And in the first instance, Judge decided the case against the state, and then scooting through, then deals with the Court of Appeal. Paragraph 26 I wanted to draw attention to. Their lordships consider that the approach of the Court of Appeal was based on a misunderstanding of what Lord Diplock was saying when he drew attention to the risks that exist under a party system in Trinidad, the power in the executive to dismiss public servants at pleasure, which was what that case was about, would make it possible for the proper performance of their public duties to be treated as subordinate to the party's political aim. He mentioned the prospect, albeit remote in Trinidad, of an armed police force being converted. It's against that background, and that's what the passage I read earlier. On the other hand, there is a function of appointing officers, this is 27, to the police service, including their promotion and transfer. That is a matter exclusively for the Police Service Commission, A40RI, the same for us in the fire. It is for, then picking it up just under H, it's for the Commission and the Commission alone to appoint the police officers. Paragraph 28, where this is an important passage because both sides make points about it. The Constitution requires that the powers which have been given to the Public Services Commission and the Police Service Commission in particular to appoint persons to hold or act in public office must be exercised free from interference or influence. A distinction, to the moving sentence, a distinction can be drawn between acts that dictate to the Commission what they can and cannot do, and the provision of a facility that the Commission are free to use or not to use as they fit. I'll come back to that distinction shortly. The appointment of a public service examination board by the Cabinet for Commission to use if they choose to do so is not in itself objectionable. The advantages
Do you mind my coming in there, Mr. Clayton? Do you mind my interrupting?
Not at all, no.
The appointment of a public service examination board by the Cabinet for the commissions to use if they choose to do so is not in itself objectionable.
Yeah.
Mr. Juss asks us, by analogy, to say the appointment of a fire service examination board by the Minister for the Commission to use if they choose to do so is not in itself objectionable.
Yes.
Now, why is his analogy wrong?
Well, his analogy is wrong because in our submission, what's happened here is adoption of a retrospective test. That is not a facility at all. A facility is the provision of a service. So that's why I drew the distinction in the case between the decision to looking ahead, having an examination board provide the facility, which I think was the very exception envisaged by Lord Hope in the case, in Cooper, and retrospective adoption. That, in our submission, is a matter of
So the
language.
original decision was perfectly okay?
No, the decision is in two parts in December 2007. Looking ahead, it said we're going to basically have an examination board undertake this work. That's not the decision under challenge, but that does look like it's loyally following the suggestion in Lord Hope's opinion that you could effectively utilize a facility offered by central government. That, on the face of it, subject to possible other requirements, which we can look at later, seems fine. But what's happened here is, which is why it doesn't come within Mr. Juss's exception, is what's happened here is there's an adoption of a previous result. And that is not the exercise of a facility. As a matter of ordinary English, facility means the provision of a service. And they're not availing themselves of an examination process. That what they actually were doing was retrospectively adopting a decision made under a process which, in express terms, was set up by the minister.
Well, subject to the argument about facility and whether it covers the situation that obtains here, do I take it that you accept that the statement by Lord Hope that the appointment of a public service examination board by the Cabinet for the Commission to use if they choose to do so is equally applicable to the appointment of the fire service examination board by a minister?
Well, yes, if the response to the board's decision had been looking ahead, we're going to rerun the processes, and in fact it's worth pointing...
I'm sorry, that distracts from the essence of the question.
Right, okay.
The question is whether Lord Hope's statement that the appointment of a PSEB by the Cabinet for the Commission to use if they choose to do so is not in itself objectionable. Whether that statement can be applied to the situation of the appointment of the FSEB.
Well,
And if it can't, well, I for one would like to know why it can't be.
well, can I? I'm going to answer.
Surely that's susceptible of a direct answer, is it not?
I will give you a direct answer, but there are a number of different propositions inherent in that. First, the first and important answer on the facts of this case is that isn't the position that arose in this case. In this case, this was the adoption of a process.
But we're asking the question before you get to the
interior
adoption.
Yeah.
Interior question.
Whether
the
I mean, if your client had been taking the exam, as it were, beforehand, all the other circumstances would be the same, then he would fall absolutely within Lord Hope's proposition.
The difficulty with that, isn't it, is that it's not a case that they're free to use it or not as they choose. As we see, it's a precondition that they use it. So that was why I was drawing attention to that.
Precisely so, if I may say so. My Lord Conworth was right to remind us of the terms of Regulation 14.
Well, I don't think we're going to go any further on this. Let's move on.
As I understand it, Mr. Clayton, your case is that what's objectionable about this document of the 21st of January 2008 is not that it accepted the examination board for the future, but that it purported retrospectively to adopt decisions which had been made in the past.
Precisely so.
Have I got that right?
That is entirely right.
Purely the retrospectivity that you object.
It's purely the retrospectivity.
So the answer to my Lord Kerr's question is that insofar as the Commission resolved to make use of the Fire Services Examination Board for the future, that was perfectly all right.
Yeah.
Thank you.
Thank you very much. I'm
Right,
grateful.
good. Let's move on then.
Right, okay. Let me just... So I just want to come back because I'd mentioned this before. Yeah, if you could then turn to paragraph 30. Paragraph 30 deals with the significance of section 123 of the Constitution, and in particular at the top of the next page, the sole responsibility for the conduct of the examination lies with the Commission. It then makes the point which I made imperfectly earlier at 31, beginning by B. The regulation does not state in terms by whom the appointment is to be made, but they have to be construed in the context of the Constitution. And my Lord will see at paragraph 32 what the board said the declaration would be. That may be of some assistance.
Yes?
So, to some extent, I apologise if I'm actually...
But that doesn't reflect your retrospectivity point, does it, in paragraph 32?
No, well, obviously...
Because the whole of this has nothing to do with retrospectivity.
No.
The whole of this comes within the point we were discussing earlier, in which you conceded.
But what you've got to face, Mr. Clayton, is that what Cooper, at least on the face of it, is about, is that the decision what system to use has to be the responsibility of the Commission,
yes,
and not of somebody else.
Yes.
And what is said against you is that the document of the 21st of January 2008 is the Commission making its own unfettered decision.
Yes. Well, the distinction that I would draw, which in our submission is important, is the use of the word facility by Lord Hope.
I see.
And there is a distinction in our submission of substance between setting up a system which runs an examination procedure which is envisaged in that letter that I took to you on the one hand, and simply ex post facto ratifying a decision which, on the face of it, looks unlawful. And indeed, it's worth emphasising that just the terms of Regulation 14 themselves, I mean, they make it with respect plain that it's in breach of the...
So if the PSC had used the FSEB after this problem became manifest and had required the FSEB to run the examinations again, and the FSEB had reported on precisely the same terms as it had previously, there'd be no objection to that.
Well, it's difficult to envisage any principled objection to that. That's a fair statement.
Which means, doesn't it, that Regulation 14 isn't ultra vires. The problem with Regulation 14 only arises if the Commission hands over the decision-making responsibility to somebody and doesn't keep control itself.
Well, in our respectful submission, actually what happened was the position that was described isn't the same as Regulation 14 either.
Right.
And the problem is it's a question of regularizing practice with what actually is happening. What's happened is the examination board is set out to a new body, but that doesn't really behave compliant with Regulation 14 either. It's a question, I'm afraid, of where the law has lagged behind the practice. That's really the point. And it's difficult, with respect, to say that the current system for future candidates complies with Regulation 14 either. That's not quite what's happened.
What happened to Regulation 14?
Well, it's just sat on the statute books.
And what happened to the examination board? Then did it continue?
Well, the examination board has then became operative following December 2007, and well, I think
continuing to operate under Regulation 14.
yes, but the problem is that the practice doesn't actually comply
All
with.
that would be perfectly okay for any future case, you say, or you accept, as I understand it. But your complaint is that they used it to make a retrospective, or to validate retrospectively a decision which had already been made.
Exactly. That is the essence of our case.
That is the point, that when they're doing it retrospectively, they're not really in control at all.
Exactly so, because they're not even doing a facility. It's just ex post facto operating the old system.
Why are they any less in control when they adopt a past decision than when they authorize a future decision?
Well, one of the differences might be, factually, is what the new system is. I mean, all that we're told is a label, and it's quite important to remember that legal labels may reflect factual substratums which have altered.
But the fact is that there's nothing in any of these cases we've looked at which really governs your case at all.
No. There isn't. Although, as I'll go on to make submissions in a minute, the approach to the Court of Appeal doesn't really do justice to the separation of powers point at all. Well, I'll come back to that.
Can we get clear what was decided for the future in December 2007? You'll correct me if I'm wrong.
Yes.
The Public Service Commission said, from now on, we're going to take over the Public Service Examination Board, which has previously been appointed by Cabinet. But that's all changed. I think it's all set out in a letter that you said was irrelevant, which we couldn't read. And I still rather would like to read it at some stage. But, correct, Mr. Clayton, proceeding, therefore, for the future, it's PSEB, which is under PSC.
Yes.
And I got the impression from page 72, which is paragraph 11 of Mr. Greaves' witness statement, that the Fire Service Examination Board became defunct at that stage.
Yes, I thought.
Is that right?
I think that is right.
Yeah.
Thank you.
And the only modification I would with respect suggest is that the fire procedure is not under the Cabinet but under a minister, that's all. It's the police are under the Cabinet process.
Of course.
Yeah, but subject to that, my Lord, I don't,
Very well.
with respect, Antonio. Can I just...
So the varies of Article Regulation 14 for the future simply don't arise because it's being dealt with in a different way.
Well, except, I suppose that's true, but it is being dealt with,
It's been dealt with by the PSEB, which is not the body appointed under the Fire Service Regulations.
Well, that's true.
I mean, let's get this. I mean, Mr. Yost will no doubt clarify all this, but as I understand it, all we're concerned is what happened in the 2006 examinations, which were under Regulation 14 and were then adopted.
Yes.
You've got 2 points about that. One is that those regulations were ultra vires. 2, that you couldn't anyway adopt them retrospectively.
Yeah. My Lord has said so. If I could just really sort of summarize where we are. I mean, our submissions, I'll just make them briefly because I think your lordships have them well in mind. The first submission is that a retrospective decision to adopt examination results breaches the principle of separation of powers. And the second submission, and it's worth reminding oneself of the language of Lord Hope's exception in Cooper, the provision of a facility that the Commission are free to use or not. And in our submission, the provision of a facility is really the provision of a service provided for the purpose. And that is not what a retrospective ratification of a decision is. It's not the provision of a service. It's taking a shortcut. It's just looking at the result of this, what the service produces. Forgive me, Lord Clark.
Yeah, I get enough.
The next point I want to make is a point on evidence, which is really, there is very, very little evidence that the state has chosen, or the respondents have chosen to put forward to demonstrate that this is a provision of a service. In our submission, it doesn't amount to the provision of a service. And what's more, and I make this point without making any criticism of the point which arose in the case I draw it from, the Belize case, but in that case, Lord Walker, in a dissenting judgment, which this is paragraphs 85 and 86 of the Belize case, reminds us...
Sorry, can you give us a citation?
It's forgive me, I think it's the last authority.
No, that's all right.
I think it's tab 35, is it?
It's tab 35. And what Lord Walker reminded us of was that judicial review is not to be conducted like hard-fought commercial litigation. And he reminds... Should we just turn up the passage? Would that be easiest?
What page is it?
What paragraph is it?
It's paragraph 85.
Of?
It's page 713. And Lord Walker, what happened in the Belize case, just to set it, it's not relevant to this, was there was effectively a material non-disclosure. And that what happened was there was a report which indicated that the site of a dam was different in character from what, and importantly different in character from what the proposal, the environmental impact assessment was. And the minority of the board, Walker and Stain, rejected, would have allowed the appeal on that basis. Lord Hoffman took a different view, but in the course of it, Lord Walker reminds us of some broad principles which, in our respectful submission, are of assistance. He begins with Huddlestone, which is, of course, a familiar case with...
Which paragraph is it?
85.
85, thank you.
Where in Huddlestone, as my lords will recall, it basically, the then master of the rolls said, you have to put your cards on the table once permission has been granted in judicial review. And it's the second passage at paragraph 86 I draw attention to. From the second sentence down, proceedings for judicial review should not be conducted in the same manner as hard-fought commercial litigation. A respondent authority owes a duty to the court to cooperate and to make candid disclosure by way of affidavit of the relevant facts, and so far as they are not apparent from contemporaneous documents which have been disclosed, the reasoning behind the decisions challenged.
Yes.
And the reason I refer to that is that the evidence from the respondents is very slight indeed. All one has is witness evidence, which is not always satisfactory because one would expect contemporaneous documents normally, and a point actually made by Lord Justice Sedley in the case I
That appears in your case. but
Exactly.
Let's just be clear on the deficiencies that you say exist in the evidence. This is on the question of whether this was a provision of a service, is that right?
Yeah, that's right. That's all.
Well, what evidence? Well, what's the species of evidence that you contemplate might be provided?
Well,
It's either the provision of a service or it's not. I mean, it's not
Well-
something that would be susceptible of substantial evidence, is it?
well, to the extent, what I am saying is 2 points. One, to say a retrospective approval is a service is allied in two different concepts.
Yeah.
But to the extent there is any ambiguity about it, one would
Still a
expect...
service, surely.
No, it's actually confirmation of the result.
And that's a service too.
Well,
Anyway, you don't need evidence to establish that.
No.
No. But all I'm saying is there's a limit on how much... there's a limit on the court's ability to analyse the material before the court in order to say that it falls...
I suppose we shall have to muddle along as usual on that front. Yeah.
Well,
I think the point is there for what it's worth, Mr. Clayton.
well, sorry, the point for what it's worth is this, is that in order to suggest that this comes within the breadth of the exception enumerated by Lord Hope, in order to come within the scope of that, there has to be some evidence to support it. And in our respectful submission, in answer to the Lord Clerk, the proving result is not that evidence.
You're saying, are you, that you would expect a board like the Public Services Commission to have internal documents, that those documents might be expected to show how and how it had arrived at the decision which is recorded on the memorandum of the 21st of January
Exactly so.
2008. And therefore you say, do you, that in the absence of it, we can't take it at face value?
Well, I say in the absence of it, you can't go beyond what it actually looks like, which is an ex post facto approval.
As a matter of interest, has anybody ever asked them for any internal documents?
That I'll have to inquire about.
Right. Bit late now, you see.
Yeah.
I understand it's a bit late now, but
Well, the advantage of not asking is enables you to makes the point.
well, with respect, it's the Huddleston principle is so firmly established about the duty of a respondent post permission or post.
No, but I mean, Mr. Clayton, you know, it would be absurd if authority was expected to produce its whole sort of library of documents. I mean, what the authority does is produce the documents which it regards as relevant to the issues, and no doubt this is what they did produce.
Well, yes,
but I mean, you know, we can't go in now, sort of 10 years later, into what they may or may not be in their cupboards. I mean, that's absurd.
I accept that. My point is precisely the one made by Lord Hughes. My point is that there would have been contemporaneous documents which are explanatory of the reasons for the decision expressed in December. And actually all we have is the letter plus some witness statements which are done long after the event too.
Yes, but I mean, if they had no power to do it, no amount of justificatory evidence is going to help them, is it?
Yes, well, I would be happy if the case
they
were
did have
decided
a
on
power,
that basis. But my point really is this one, is that in order to squeeze out from the evidence that it comes within the Lord Hope exception, there is a paucity of evidence that is before the court.
Was
So
this point made before the Court of Appeal or the first instance judge?
well, it's there were quite a lot of points made.
Yes, well, I can't detect from reasonably careful reading of both judgments that this point was made.
Well, I've made the point.
Yeah.
Seems to me you might win this appeal, but it's hardly likely to be on this point.
No, I mean, well, that may be a convenient moment to turn to the Court of Appeal's judgment, because with respect...
You'll keep in mind, Mr. Clayton, that although we've been asking you a lot of questions, you have indented for 1 hour to 1.5 hours, and as I understood your earlier submissions, Mr. Ramlogan intends to follow.
Right, yeah, and he is going to be short, but can I just deal with this is
Yes.
the last submission I propose to make.
Yes?
The Court of Appeal decision, which appears at 203. Sorry, and I want to go to paragraph 15, which,
205, then.
yeah, sorry, I'm just having to scroll. Yeah, it's at 207.
Yes.
And really what I want to draw attention to is the approach taken by Justice of Appeals Smith at paragraph 15 and 16. In the present matter, as the trial judge observed, there is no evidence nor any allegation for that matter that the Commission's decision to use the results of the examination board adopted by the board is or was tainted by any influence or interference from the executive arm of the state. Like in Cooper and Barbosa, the state had provided a facility. That decision was not on the facts illegal or ultra vires. I've already made the point about facility, so I don't repeat it, but the first sentence, with respect, puts the point about separation of powers much too broadly. Separation of powers doesn't involve a requirement to demonstrate actual interference. Subject to that, I have no further submissions unless there's anything else I can assist your lordship with.
Is 16 right? The appellant's arguments and evidence in this case were founded on the issue of the legality or the vires of the Public Service Commission's decision only.
As I understand it, the decision we're effectively talking about is the document I handed out.
21st of January 2008.
Yeah.
Yeah.
So on our analysis, it is ultra vires and unconstitutional.
But I thought the actual focus was upon the decision of the Public Service Examination Board to adopt.
My lordship is right. I expressed it again too broadly myself. It's the second bit of the two-limb decision.
And then, of course, it having been adopted, the Public Service Commission used.
Yes, precisely so. Thank you very much.
Thank you, Mr. No, not at all, Mr. Clayton. You had to ship a lot of outward fire, and you coped admirably with the electronic challenge as well. Now, Mr. Ramlogan.
To avoid the pitfalls of the electronic bundle and my laptop freezing, if I seek my lordship's leave to refer to the printed case. Yes. Perhaps just to correct one on a couple of footnote housekeeping matters.
Yes.
Documents were in fact requested, and you will see from the record at page 38 of volume 1, there were two applications under the Freedom of Information Act prior to the filing of this claim, my lords, where we were seeking information about this board. One must understand this sequence of events after the judgment in Cooper and Barbosa. The sequence of events was such that we were confronted with the station notices, and that's all the appellant would have had in his possession. And when he got those station notices, he assumed that the examination board that was being referred to in those notices was in fact the examination board set up under Regulation 14 by the minister. So he'd asked under the Freedom of Information Act for clarification as to which board are we talking about, because there is some serious confusion between the Public Service Examination Board and the Fire Service Examination Board.
Yes, but as I understood Mr. Clayton's criticism, it was that no documents had been produced by the respondent touching on the question of the decision to adopt the examination board's results. Now, looking at page 38, I don't think that documentation has been requested, has it?
So, well, not that particular documentation, but my lord, had we been provided with the information requested in a fulsome manner, one might have perhaps gotten a little more than we have managed to eke out from the respondent. For example, the minutes of the Public Service Commission meeting at which any decision would have been taken should have been disclosed.
Well, is that requested
No, that was not requested. I'm saying the duty to make full and frank
Yeah, but if
disclosure.
you'd wanted it, you'd have asked for it.
Well, my lord, no.
Or would you deliberately not have asked for it?
Well, my lord,
Fair.
one would not have asked for it because the laws that we
Puts
understand.
you in a stronger forensic position.
Well, no.
They don't
You
produce.
answer. I mean,
Yeah, my lord, the law as we understand it from ex parte Huddleston onwards is that once leave has been granted in a judicial review claim, there exists a duty to make full and frank disclosure
yes, but I
on
mean,
the
what
part.
document are you saying you wanted that you didn't get? Or what information are you saying you wanted
Well, my
that
lord,
you didn't get?
it's a bit difficult to answer in a vacuum because we don't know what
Yeah, but you were
documents they
making a
had.
point about the fact that your client didn't know which board it was.
Yes.
But there's no doubt that the board which eventually took the exam was the Fire Service Examination Board in 2006, was there? Or is that-
No, there is none. And my lord, can I just on that
And
note,
he knew that, because that's why we're all here.
indeed, my lord, now can I make a slight correction to an issue that was raised earlier? It's not that the Service Commission has assumed conduct of the Regulation 14 board appointed by the minister. It's that the Service Commission has appointed its own examination board. And you will see that from the evidence at page 50 of the record. I think we've mixed them up a bit, quite frankly. But it's not that the Service Commission has assumed control of the board that was appointed by the minister.
I don't think anybody
fair
meant to
enough.
suggest it.
Well,
If
fair
I
enough.
seemed to suggest it, my terminology was very poor. We understand that point.
Well, great. So, my lord, there are in fact two different boards,
Yes,
and
sure.
the commission has set up a different one.
I think
Now,
that's
my
well
lord,
understood.
this matter is of some importance because the issue of the independence of service commissions in Trinidad and Tobago touches a very raw nerve in our society. And it is because of the need for political insulation in a small society that is racially plural in nature, and given the kind of political structure that we've operated under for many years. And my lords, if political insulation is meant to be the justification for having independent service commissions, the reasoning in Cooper and Barbosa may be a little too wide and has been causing some problems. In that, my lord, I don't accept that on the one hand we can say an independent body that is existing to prevent public officers from political interference, be it direct or indirect, that political insulation can be reconciled with the other statement that they're entitled to rely on a board appointed by a government minister.
So Lord Hope was wrong.
My lord, I say the scope and the language is one that is too broad. If you take your core constitutional function and were to subcontract it or delegate it to the political executive of the day, then you collide frontally with the necessity for political insulation. And what you've done is to destroy the very philosophical underpinning in the Constitution for having these autonomous bodies. And that is why Regulation 14 and the virus of it is so critical to Trinidad and Tobago. It is quite simply not on, in the wake of Cooper and Barbosa, that one sentence notwithstanding, for the Service Commission to take its core function, which is an examination, which is a precondition to getting promotion, or which effectively dictates promotion in reality. It can't be right to say, I have a sole and exclusive constitutional jurisdiction to determine promotion, but I can then pass a regulation to subcontract or delegate, whatever the terminology we wish to use, that to a body appointed by a single government minister with political responsibility and control for the fire service. That, quite frankly, collapses and conflates the Service Commission into the Ministry of National Security under the command of the minister.
But I mean, this is a problem of 2006.
It is.
It's not a current problem.
It is, but my lord, it then brings us to the root, it brings us now to the problem ab initio.
Yeah.
When Cooper and Barbosa was decided, what was the effect and legal consequence of that decision on the status quo back then? The status quo post-Cooper and Barbosa had to be that no board could have been set up under Regulation 14. A board could not have been set up under Regulation 14 because Cooper and Barbosa had made it abundantly clear that the sole jurisdiction for promotion was in the lap of the Public Service Commission. And that being the case, it could not have lawfully occurred.
Yes, we discussed this with Mr. Clayton. Is your submission that all the appointments made under those regulations from 1998 onwards were invalid?
The answer is yes, and we confronted this very problem in Cooper and Barbosa, because if they held that the cabinet-appointed committee, which had been setting the exam since independence, had been wrongly arrogating onto itself the right to do so, the legal problem that we identify as to what is the consequence of that presented itself back then.
Yes, but what is the consequence now of us saying that the regulations were invalid in 1998 to 2006?
The way the matter was resolved
what is the consequence now? Don't care about Cooper.
Yeah, well, my lord, the consequence, I don't think it would have any practical consequence 9 years after the fact. I don't think it will have any practical consequence in terms of the appellant's career. But it does have significant implications for the rule of law and the constitutional principles that underpin the architecture for our Constitution. It does...
I understand that. I understand why it's an important principle. I just want to understand the practical consequences. No, there's no practical consequences for you. No practical consequences for anyone else?
No, and given the 9 years that the case has taken, we will not be advocating a position based on practical consequence. Just to mention, my lord, in Barbosa, at first instance, the doctrine of the de facto officer or executive necessity was relied upon to say, though those appointments since independence would have been invalid, we won't interfere with them as a matter of executive necessity. So that principle will, I suppose, will help us to some extent here.
Anyway, you're not suggesting that should be a problem for us.
No.
You're simply concerned with the point of principle that this type of board was invalid.
Correct. Correct. And my lord, if in the wake of Cooper and Barbosa, in the wake of Lord Hope's judgment, if in the wake of that, the results and the status of the cabinet-appointed board was such that it would have been null and void, or it would have been tainted or infected by the interference or indirect, the problems created by the position or understanding, the misapprehension by the Commission that the cabinet-appointed board was responsible for conducting the exams. That misapprehension gave rise to a situation where the process utilized by that examination board was one that was tainted. It was vitiated. And having been vitiated and so tainted, I don't think that retrospectively you can come in this case and say, well, look, we accept it. It's quite frankly swallowing the fruit from a poisoned tree, as it were. And the tree was poisoned in this case because the examination board was set up after Cooper and Barbosa. The chronology in this case is Cooper and Barbosa's judgment came in July 2006. After that, in the wake of that judgment, they then went ahead to establish a Regulation 14 board, which could not have been done in light of that judgment.
Sorry, which one?
The minister, the Regulation 14 Ministers Board.
Called?
Sorry?
Called? What was its name?
It's actually the respondent. It's the Trinidad and Tobago Fire Service Examination Board.
I thought you were going to say, after Cooper and Barbosa, the Fire Service Board examination held exams.
Yes, they did.
I thought that was the focus.
Indeed, my lord, yes, you're right. And not only did they hold exams, they actually went on to publish the results. And what they did was to come up with this colorable administrative thing where you had a station order revoking those results, and then the Public Service Commission Board said, we adopt it. In one fell swoop, in one breath, they revoked it and adopted. approbated and reprobated, blowing hot and cold. But the point is, we say that the status of those results in the wake of that Cooper and Barbosa judgment is such that it's null and void and of no legal effect, such that it was capable of being lawfully adopted by the Public Service Commission and its examination board. It could not, they would have been accepting the minister's...
Whether retrospectively or prospectively, is it?
I say in both cases.
But you say that, that the same illegality or unlawfulness existed well before this case, 1999, or for years and years and years.
Yes.
Is the logic of your case.
Yes. That's correct, my lord.
So you're putting it much more extremely than was
Perhaps.
on behalf of your client only 20 minutes ago.
Perhaps, my lord. But the short point is, my lord, Regulation 14 cannot exist, and it would be impossible to reconcile its existence with the principle of an autonomous, independent, constitutional service commission with sole and exclusive jurisdiction to promote fire officers, public officers, because, effectively they've subcontracted a core constitutional function to the executive. And that was the whole point in having political insulation for public officers. And, my lord, this is of importance in our country because when it comes to the security services, which comprises the prison service, the fire service, the police service, and the like, these are considered very, very good careers, but they are also considered security services that can have an impact on the stability of a democracy, because it comprises the bundle of services that form the apparatus of your national security agencies. And therefore, to insulate them from political interference is extremely important from a socio-political and constitutional perspective. And that's why the rule of law must bite very hard on any attempt that can lead to direct or indirect interference. And the judgment in Cooper and Barbosa, unfortunately, led to some confusion on the part of the state, whereby it interpreted it exactly as my lords alluded to earlier, by that one sentence, that there's nothing wrong if they consciously take a decision as a service commission to rely on services or facilities provided by the executive. And I say that that needs to be clarified. I urge the board to revisit it.
This is the Lord Hope sentence wrong point.
Indeed, my lord. And because I say, taken at face value, it would mean that there is nothing wrong in the Judicial Commission, for example. The Judicial Commission sets exams for judges to enter and to enter the High Court. So if we use the analogy, is it okay for the Judicial Commission to say, well, I'll let the Attorney General, the Minister of National Security, set up an exam board, they correct these exam scripts, and you compile an order of merit list, and we decide who will be judges? It can't be right.
Can I just be clear which sentence you're saying is wrong?
Certainly, my lord.
Paragraph 28, is it?
Certainly. Yes, I think if I take you to page 306 of the record, where we find the judgment in Cooper and Barbosa.
Paragraph.
And if I take you to page 111, letter B, there is room in this, perhaps I'll just read it. The Constitution requires that the powers which it has given to the commissions and to the Police Service Commission in particular must be exercised free from interference or influence of any kind by the executive. There is room in this system for the taking of some initiatives by cabinet. A distinction can be drawn between acts that dictate to the commissions what they can and can't do, and the provision of a facility that the commissions are free to use or not to use as they think fit. And lower down at F we're told, perhaps at E we're told, so the appointment of an examination board is an essential part of the whole process. The Constitution, for its part, does not permit the executive to impose an examination board on the commission of the executive's choosing. It is for the commission to exercise its own initiative in this matter, free from influence or interference.
I'm asking you which sentences are wrong, not which ones are right.
Well, my lord, it would be the one at F where it says, on the other hand, it cannot be criticized if it chooses, not to do so, or to do so as the case may be. I suppose it would be the one at B, really. A distinction can be drawn between acts that dictate to the commission what they can or cannot do, and the provision of a facility which the commissions are free to use or not as they think fit. I say, my lord,
What's wrong with that?
well, what's wrong with it, my lord, is this. If the political directorate or the executive provides a facility under the jurisdiction and command and control of a government minister, an independent service commission that is there to provide political insulation simply cannot.
I see. So if it's appointed by a minister, then it cannot be right for them to be free to choose it if they wish,
No.
because it's infected
That's
by...
the point, my lord,
I see.
yes.
I understand.
That's the point.
Thank you.
And that would apply to any service commission.
This is not a point that's in your case, is it?
Sorry, my lord?
This isn't a point which is in your case.
But, my lord, it is in fact the point we ran in the High Court and Court of Appeal.
I'm just asking about your case at the moment. I don't see this point in your case. And I noticed you stopped before the sentence in Lord Hope's judgment.
Yes.
The appointment of a public service examination board by the Cabinet for the Commission to use if they choose to do so is not in itself objectionable. Now, do you say that that is wrong?
I do, my lord. I say it is objectionable, and
What I'm saying is that I wouldn't have guessed that by reading your case.
well, I apologize, my lord.
Maybe,
Sorry.
I mean, I can see you can get more enthusiastic as the day goes on.
Well,
But I mean, we've all had that difficulty
my lord,
over the years.
I thank
Anyway, there it is. Thank
I
you.
thank you for the compliment, my lord. My lord, the short point is, it raises very important constitutional questions which impact on the rule of law. And it would be, can I just show my lords what has been the development since Cooper and Barbosa in Trinidad and Tobago?
You remember that you have...
I do, my lord. I am
left.
conscious. Can I take you to page 366, a case of Haridat Miraj in the High Court in Trinidad, decided by Justice Rajkumar, as he then was, who was subsequently elevated to the Court of Appeal. And I will show you if I take you to page 368, my lords.
368.
368, yes. The process for the appointment of a commissioner and deputy commissioner of police was revised by the executive, and a legal order was passed. And the terms of the legal order sought to introduce a role for the executive in that process, thinking, as it did, that the jurisprudence in Cooper and Barbosa might have permitted it. And you'll see at page 368, these were the terms of the order.
Paragraph?
Sorry, my lord?
Paragraph number.
Paragraph 3, my lord.
Thank you.
The commission, on the request of this is the Police Service Commission, on the request of the Minister of National Security, shall, in accordance with Section 20 of the Central Tenders Board Act, contract an appropriate local firm to conduct the recruitment process, inviting applications for the positions. The firm shall select the most suitable candidate from the assessment process, and at D, the firm shall submit to the Commission the results of the assessment process in the form of a shortlist. This, my lord, is known as an order of merit list, which is precisely what Regulation 14 provides that the Minister's Board would do after the results obtained from the examination. So it's analogous. And if I take you to the following page, 370, paragraph 5, the conclusion of the judge, he says at Roman numeral 2, the order, providing as it does for a role for the minister in triggering the recruitment process, is in that respect ultra vires the Constitution. Likewise here, with the minister being in control of the board that sets the exam, which is the precondition and prelude to promotion.
Yes, now I'm afraid your time is up, Mr. Ramlogan.
My lord, can I be permitted just a couple of minutes injury time?
I'm not going to allow you a couple of minutes injury time. If you can summarize it in
my
30
lord,
seconds, then...
But, my lord, thanks. This judgment shows, my lords, that the existence of a parallel jurisdiction in the executive is not, it cannot be countenanced because it would interfere with the doctrine of insulation from political interference. And I commended this judgment to my lords as an example of how the scope and breadth of Lord Hope's statement in Cooper and Barbosa, which shows why Regulation 14 must be ultra vires, is something that we must confront in this case, my lords. I thank you.
Thank you very much indeed.
I'm obliged.
Now, Mr.
I thought I can quickly dispose of Regulation 14 if
Yes?
the court so wishes. Well, if one looks at Regulation 14, it's been argued that it is, in fact, ultra vires, but a moment's look will tell us that it is not. It firstly has firm statutory underpinnings. It's made under Section 34(1), whereby for the good order and governance of the fire service, the Minister for National Security may make regulations. Now,
Have we got Section 34, Mr. Chairman?
my lord, we don't. We do not have that anywhere in the bundle. I've not been able to see it.
Yes.
But Regulation 14 has been set out in the High Court judgment at paragraph 3. It's set out also in the Court of Appeal judgment at paragraph 7.
Sorry, I can't follow you.
Say that again.
I think we'll have to slow down just a margin.
Regulation 14 has been firmly addressed both by the High Court.
Yes. The point is not that it hasn't got a statutory underpinning, but it is contrary to the constitutional principle.
It is not unconstitutional simply for this reason. All it says is that the minister is required, in writing, to set up an examinations board.
Yes,
That's all it is.
but it says that is that under the regulation, that is a precondition. You've got to get through such an exam if you're going to be appointed.
Indeed, indeed.
Well,
The board is
So
set
clearly
up.
the minister is having an influence in your
The
appointment.
point I make is that no matter how large or small a society, someone in the executive has to appoint an examinations board of this kind. The Minister for National Security, as is in charge of the fire service, makes that appointment in writing. Thereafter, and this is a crucial point, it remains up to the examinations board to, quote, set and conduct at least once a year, unquote, the examination. So the minister's not involved.
Of course he isn't, but that was the same in Cooper. Cooper, the vice appears to be the fact that you couldn't have the minister appointing the examination board. It wasn't that the minister was actually setting the exams.
My lord, the position currently is that the PCA, the Public Service Commission, has in fact insulated itself twice. Firstly, by reconstituting the Public Service Examinations Board. Secondly, allowing thereafter the Public Service Examination Board to adopt the results of a facility provider.
Yes, I mean, post-2007, everyone accepts, I think, well, at least we're not concerned with any attack on what's been going on since 2007. What we are concerned with is what happened in October to December 2006, and whether that was valid, and whether that could be validly adopted.
Yes, my lord, the argument that the other side puts is, and it's the argument that my learned friend Mr. Clayton began with, it's set out in their case, and it's quite a leap, because one sees at paragraph 40, subparagraph 2 of the case for the appellants, that in adopting retrospectively, as we are now told, the 2006 examination, the minister was selecting candidates for promotion. That is quite a leap. That suggests a kind of arbitrary interference that Cooper was all about.
If that's the point, I agree with you that it
Yes.
doesn't work.
But what I say is this, that what has happened, of course, since then is that an examination that was sat back in 2006 has subsequently been adopted. Yeah. The issue then arises as to whether...
If we do address the point I'm trying to put to you, I'm sorry. What's being said is that the regulation 14 was invalid under the principle of Cooper because it involved the minister appointing the exam board, and it wasn't a case like Cooper where there was a public service exam board which the Commission could choose to adopt. It was a specific fire exam board which
was a precondition of promotion in the fire service. Now that's the point, and I'd be grateful for you to address it because it's quite an important point.
In many ways, the entire debate on that question is academic, because I think in response to my Lord Clerk, I think it was, the Fire Service Examination Board is now defunct.
Yes, I mean, yes, I fully accept.
Yes.
It may be the proper answer to say, well, this may have been a problem then. It's not one which should result in a declaration now because it's not suggested it actually has any practical effect now.
Yes.
That's a different point.
And Mr. Ramlogan accepts that it has no practical effect. What
but I still would like to know whether the point is right or wrong, viewed as at 2006.
Well, my Lord, it would seem to, I make two submissions. The one is that it seems to me that as Regulation 14 stood, it was not ultra vires because it simply involved the minister setting up an examinations board, thereafter leaving it up to the examinations board to set, conduct and assess those examinations, leaving it up to an applicant in question to in writing apply to set those examinations. There could be nothing wrong with that. But my second submission is that it is in any event now OTOs. It is academic, it is a redundant point, because what has then, since then happened is the exercise of a facility. Now, my learned friend, Mr. Clayton, disagrees with the use of the term facility or service because he says that this was under a previous regime. But it raises a question as to what one might mean by a facility. Of course, a facility may well be the physical structure of a building, but it could equally mean availing oneself of an examination set by a body at a time gone by. And if all that has happened here is for the PCA to say, hand me over from over there the results of the 2006 examinations, bearing in mind that the Court of Appeal spends a great deal of time towards the end of its determination judgment to say that really no question has ever been taken about the reasons for why there was a delay and what one might go in terms of any malafiders involved, bearing that in mind that the only question was the adoption by the PCA of the results of the 2006 question. All that you have simply here is the use of an examination conducted back in 2006, availing oneself of that facility in a small society where there are going to be expenditures and use of resources involved to reconstitute those exams again, which is why I say that what the PCA has actually done is to have insulated itself precisely in the manner that Cooper envisaged, which is to reconstitute the PSEB, allow the PSEB to adopt those results, and then on that basis for the PCA to make its announcement. Nothing could be remotely wrong with that. And on that question, my Lord, I need fall back only on paragraph 28, which has surfaced again and again. Both Mr. Clark, my Lord Clark mentioned it, and also Lord Hughes. I mean, that really explains perfectly well why this is a complete red herring. If I could, my Lord, very quickly take you to the judgment in Cooper in this respect. We could begin in that context with paragraph 28. It's been gone over before as well, where the constitutional principle there, and what Mr. Ramlogan submitted was that the consequence of the adoption in 2006 was not a practical consequence, but one involving the rule of law, the separation of powers. Well, paragraph 28 tells us what the constitutional principle is, and that is that the Public Service Commission must be free from inference and influence of any kind by the executive. Having said that, there is room in this system for the taking of some initiatives by the Cabinet, and then a distinction has been drawn, and my learned friend, Mr. Clayton, actually begins with this in his submissions in the written case. The distinction is between acts that dictate to the commissions. Now, one cannot find any vestige at all of any suggestion that the commissions here were being dictated in this particular case. All they've done of their own free volition is to just adopt those results as they were. But the distinction, that the constitutional principle at hand, is acts that dictate the commissions as to what they can or cannot do, and the provision of a facility that the commissions are free to use or not to use as they think fit. And the appointment of a public service examination board by the Cabinet for the commissions to use if they choose to do so is not in itself objectionable. And as I think my Lord Clerk said earlier on, what would be wrong with our side saying that it's not the adoption by the police but by the fire service? What would be objectionable about that? And the advantages of using a centralized body are then set out and so on and so forth. Now, how do we get to this paragraph 28? Well, my Lord, it's important I take you to paragraph 23 in this respect, because paragraph 23 is a complete answer to everything that they say.
23 of?
Of Cooper, my Lord. You have the rather benign point at the beginning that the fact that no mention is made in the Constitution of the Public Service Examination Board opens the door to the argument as to who should set it up. Should it be the Cabinet, in which case it would assume to itself the power that it did not possess. And now this is the important bit. There is no doubt that the constitutional principle would be breached if that body were to be firstly used as an instrument which enabled the executive to interfere directly or even indirectly with the appointment and tenure of public officers. Now, there has been no suggestion that either of the bodies in question here have been used as an instrument, even in a small society like Trinidad, in order for the executive to interfere in this manner. Secondly, the point is made, on the other hand, policies aimed at uniformity of standards, and these are all the arguments for why one would use a body such as this. Secondly, the consistency of practice in making, thirdly, the appointment of public offices, fourthly, the economic use of limited resources, and fifthly, to avoid duplication, are all matters of legitimate concern to the executive. And all of these fall within the ambit of the general direction and control of the government that follows from the enabling power of Section 75 of the Constitution. Now, my Lord, what Cooper was really about is set out in the prefatory remarks very early on at paragraphs 5 and 6 of that judgment, where paragraph 5 tells you that there are two issues. One was whether the appointment of the PSB by the Cabinet is unconstitutional. That's paragraph 5. And the second is whether the delay in releasing those 2002 results was unreasonable. But the point is then made at paragraph 6 that by the time that the Privy Council gets hold of the matter, the constitutional principle was the only live issue before the Privy Council. And it's interesting to see the way in which this is actually set out. The constitutionality of the appointment was not the actual focus at all, which is what those on the other side are arguing, but the constitutional relationship between the Police Service Commission and the executive, and secondly, where lay the responsibility for conduct of examinations for appointment. I mean, that was a question as to where lay that responsibility. Now, my Lord, it's been suggested on the other side that Cooper is far too wide, and in a society like Trinidad, it is prone to giving rise to problems. But, my Lord, I would suggest that Cooper has in fact been overstretched. Cooper was not about not being able to avail yourself of the results of a body even set up by a cabinet of a minister. Cooper arose, and it's little wonder that it did arise in the way that it did arise, was because of an ill-conceived media statement at paragraph 2 by the Police Service Commission. This is page 5 of the bundle and the internal page 103, where given the delay in the release of the results at paragraph 2, the Police Service Commission on 8 July 2003 issues a media release where it disclaims any responsibility for the conduct of the examinations. And just the first couple of lines of that statement, quote, "The Police Service Commission informs that the sole responsibility for the conduct of examinations falls under the purview of the Public Service Examinations Board," that's the PSCB, which is a cabinet-appointed body, the management of which is the responsibility of the employer. my Lord, if I could just pause here, the reference to the employer is quite significant because there is discussion in Cooper of the role of the executive, this is paragraph 27, in terms of the function of setting down the terms of service, including the contract, which is a matter entirely for the executive when it comes to actual appointment, and the function of setting up the examinations, which is an entirely separate matter in the purview of the public service commissions. So given that you, back again to page 5, have this public service commission saying it's not our responsibility, it's the PSEB, a cabinet-appointed body, the management of which is the responsibility of the employer. It is small wonder that there was a challenge by the residents of Trinidad to that statement. The board is not a part, it goes on to say, of the Police Service Commission, nor for that matter, any of the other service commissions. Now, given that that was the case, eyebrows were bound to have been raised, and there was a challenge to this. And all that the Privy Council, the board, is doing in that case is looking at that argument and then addressing it at paragraph 23, making it clear that the constitutional principle, by this stage they're agreed that the constitutional principle is to do with the relationship between the various organs of the state. And the constitutional principle here is whether really the examination board is used as an instrument which enables the executive to interfere directly or indirectly. But that is not to say that it cannot use, given the limited resources, the facilities that are laid at its disposal. And we eventually end up with paragraph 28, where there is that emphasis to the fact that there is room in the system for taking some initiatives by the Cabinet. In fact, it goes so far as to say that those some initiatives by the Cabinet would involve also the provision of a facility by a commission that is set up by the Cabinet. And that in itself would not be actually a problem. So contrary to what the other side says, that there has been a misapprehension of a Cooper by the Court of Appeal and the High Court back in Trinidad, I would submit, quite frankly, that the misapprehension lays at their door.
But you said that Cooper had been overstretched, and I'm not quite clear that you've explained that particular
my
submission.
Lord, what I mean, I'm grateful for that entirely valid point. Cooper is not saying that you cannot use at any stage the results, the facilities of a body where the Cabinet or the Minister has had a hand in setting up. And this was the case both in relation to the PSEB, which was set up by the Cabinet, and I would submit is the case now with the FSEB, which is set up by the Minister of National Security. Because all you're having the FSEB do is to conduct examinations with no suggestion at all being made of any impropriety, any taint, any blemish, any bad faith. And given that that is the case, this is, par excellence, the use of a facility at that time.
I suppose on that date in December 2007, when the PSEB was reconstituted. Now, what are we going to do about 2006? I suppose they might have said to themselves, well, we haven't yet got any expertise in setting exams for firefighters.
Yes, my Lord, the other way of looking at it is this. What if we would have, in fact, turned the tables around and we had Mr. Imtiaz Mohammed, the appellant in this case, actually having back then passed his examinations? If he had had his examinations passed, and I noticed that this was in fact one of the earlier points taken by Lord Kanwath when he asked Mr. Clayton, what are the consequences for your client of this? If he had passed his examinations, only then to be told that, well, actually, this was under the previous, now much discredited regime of doing the exams, and they are therefore no longer valid. Would he not be aggrieved by that? What if one goes one stage further? He was asked now, having passed those exams, to resit the exams again because they are now under the current regime. And having sat them, he fails them. Would he not now be even more aggrieved in saying, I passed them the first time around? The suggestion that one cannot avail oneself simply of those results as then set by an examination board, no question taken about the manner of marking, selecting, none of that has ever been an issue. The case, as we can see from way below, has been little more than a series of individual complaints that have gradually been built up. But there has never been any challenge to the nature of those examinations, never been any challenge to the reasons behind that, simply that the adoption of those exam results was not proper.
Can you just clarify one point on the regulation? We don't, unfortunately, have the police regulations, but we have them set, the relevant Regulation 19 set out in paragraph 14 of Cooper, and that talks about, in paragraph 1, such examination board as may be appointed for the purpose, but doesn't say who's going to appoint it. And then 2, we have the director responsible for the conduct of examinations, and that's the director, I think, of personnel administration, who's part of the executive. Yes? Now, when we go to paragraph 32, I think it's probably just a mistake. His Lordship said they will declare the sole responsibility of the Commission to appoint the examination board referred to in Regulation 19.2. That should be 19.1, I think, shouldn't it? Because the examination board is referred to in 19.1, not in 19.2. But he deals in paragraph 31 of the more limited role of the director, who's responsible for the conduct of the examinations under 19.1, but not the appointment of the board.
Yes. My Lord, I
mean, is that right? I just think it must be a mistake in paragraph 32. But we can probably see if we can find the actual declaration. Would you agree?
Yes, my Lord, I would. And paragraph 32 states that their Lordships will therefore allow the appeal. They will declare, contrary to the media release of 8 July, that it is the sole responsibility of the Police Service Commission.
Yes, and under 19.1, not 19.2.
Yes, 1991, that's right.
Thank you.
And my Lord, if I could just add to that, what we find in the instant case is, of course, the letter of the Director of Personnel Administration. I have a lead copy, and I undertake to have some copies printed out because they had been emailed across over the lunch break. But that letter, which is of the 21st January 2008.
What are we talking about? Is it the letter that we can't read? And
My Lord, it is a letter, indeed. It is a letter that you cannot read.
It's the loose document.
There are several documents we can't read, Mr. Justice.
I think it's the letter which Lord Wilson has been talking about and which we can't read. Is it?
I'm talking about P58 and P59, Mr. Justice. Are you talking about that?
I'm talking about the letter of the 17th January 2008.
I can't read the date, Mr. Justice.
Yes. My Lord, it's in fact the letter that both the Court of Appeal and the High Court refer to, whereby the director, the DPA, writes to the Minister to say that it is I who has the sole responsibility.
Hang on, please. Is the last line of the first page of the letter you are talking about, which I think is readable, the Fire Service Examination Board therefore must be appointed by the Service Commission?
Indeed.
Right, well it's got about 4 or 5 different numbers. It's 56 in some, it's 58 in one of the others, I think. But that is a letter, is it, of the 17th of January, 08?
That's right, my Lord.
And it's from whom to whom?
It is from the Director of Personnel Administration.
Of what body?
Of the Service Commission's Department.
And he's a member of the executive. He's a government.
Yes.
Right.
And it is addressed to the Permanent Secretary at the Ministry of National Security.
So it's intra-government correspondence.
Yeah. That's correct, yes.
What does it say that matters?
Well, what it makes abundantly clear, contrary to the position, diametrically opposed to the position in Cooper, where the opposite happened, is that following the Privy Council judgment in Cooper, the sole responsibility, and this is probably what your Lordships cannot read, it's the middle paragraph, for the conduct of examinations for appointment and promotion lies with the Commission. Now, as I say,
it must be under this judgment. The Privy Council recognised that the underlying sole responsibility for the conduct of nominations, is it?
Conduct of examinations.
Examinations.
Yes.
For appointment and promotion lies with the Commission. That's the public, well, whichever commission it is.
Although the judgment dealt with the Police Service Commission, it should be noted that the Public Service Commission regulations are the same and the judgment applies to the Police Service Commission.
Mr. Justice, whenever Lord Kerr presides over a hearing, it proceeds genially as it has, but at the risk of being a little bit more critical, it's not good enough to be supplied with an allegedly important letter which is illegible.
My Lord, I've just been handed up a note to the effect that clean copies of these have in fact been handed up.
They have.
Yes.
Have been handed up already.
I'm afraid I don't have one.
You've not?
No, I haven't been given a clean copy.
Let's have a look. I don't think I've got a copy either.
Well, is this an exhibit to an affidavit?
I haven't seen
Yes,
it yet.
it's an exhibit to an affidavit. Well, we have just been handed an affidavit. What's the exhibit number, please?
2, my Lord.
Exhibit number 2.
GJ, yes, got it.
Oh, yes, that's right. GEJ2, is that it? It's in this,
Oh, I see this bundle.
and it's about two-thirds of the way through, and it says Appendix 8 at the top. And it begins, I refer to your letter dated the 5th of December, is that right? And it's this third and fourth paragraphs you're referring to.
Hold on.
Yes.
And the first paragraph, after I refer to your letter, begins by saying that I confirm that arising out of the Privy Council decision in Cooper, the correct course of action remains the revocation of current appointments to the board. So, my Lord, just to sum up this particular part of my submissions, Cooper arose in very different circumstances where a media release from the Commission disclaimed all responsibility, put it on the PSEB, stated that it was a cabinet-appointed body, and then went on to say that the board is not part of the Police Service Commission, nor for that matter any of the other service commissions. That led to a challenge, and the results of the challenge were, as my Lord Kanwath has pointed out, what you see at paragraph 32, where the Privy Council states that they will declare that the sole responsibility of the Police Service Commission is to appoint the examination board. In
Mr.
this
Cast,
case,
now we can read this letter. The last sentence on the first page says the Fire Service Examination Board, therefore, must be appointed by the Public Service Commission. I thought we had ascertained that the Fire Service Examination Board was defunct from that time onwards. I thought Mr. Greaves, who'd been a member of it, said so.
yes. My Lord, it was reconstituted. That's the point about it. It was reconstituted so that it was now appointed by the Public Service
I thought
Commission.
it was the Public Service Examination Board which was reconstituted, not the Fire Service
Yes,
Examination
I
Board.
stand corrected, my Lord.
So
That
can
is
you
correct.
please explain the last sentence?
Well, my Lord, it remains defunct, but what you have are the examination results that were taken at the time.
No,
Right, I think this was the advice that was being given by
Yes.
the writer of the letter to the ministry, saying that if you're going to continue the Fire Service Examination Board, it's got to be appointed by the Public Service Commission. I suspect what happened was they decided instead to reconstitute the PSEB and use it for this purpose. So I suspect, I mean, we don't know, but I suspect it is, as said, the Fire Service Board as such became defunct.
Yes.
And we had, but I mean, I think this letter was suggesting an alternative which probably wasn't followed up.
Yes. But, my Lord, all I say is that
And what is important about this letter is it does make quite clear that it was accepted following Cooper that the mode of appointment under the Regulation 14 could no longer be treated as valid.
that's right. And if the constitutional principle in Cooper is to do with where lies the relationship between the executive and the commissions, then what we have seen the DPA do there is to make sure that that constitutional position is absolutely clear and at the forefront of the minds of everyone. And all this is simply the adoption of a facility in the way allowed for at paragraph 28 of Cooper. There simply cannot be any criticism of this and to suggest, as I've pointed out already, that really it is a minister making those appointments is altogether far too far-fetched. There simply is no basis for that. My Lord, the only other point I would make is simply this, that of course one could argue that, and my learned friends opposite would argue this, that there is perhaps some merit in a system of democratic governance to have a degree of institutional hygiene, if I can put it that way, and that this is what one would to strive to achieve. But quite frankly, Cooper is not going as far as that at all. Cooper is simply saying that the constitutional principle is that about the relationships. And given that that is the case, what they've done is to, as I say, doubly insulate themselves so that the Commission now has the sole responsibility. The Commission declares the results, but allows the PSEB, which is appointed by the Commission, to adopt the results by the Fire Service Board. My Lord, unless there is anything else, I think I've dealt with the question of retrospectivity. I would submit is neither here nor there. To suggest that because results have been adopted retrospectively, it's not availing oneself of a facility is neither here nor there. One could have exams taking place in this country a year ago, which are then adopted by another body. It's something that's plainly allowed for by paragraph 28 of Cooper. So I really can see no merit in that argument. These were simply exam results. They would have led thereafter to an interview. Even in the case of Thomas itself, there was a suggestion of the suitability assessment process taking place. And all that has happened here is simply the adoption of examination results in a manner which was entirely right and proper for the PCA to do. Unless there's anything else at this stage, my Lord, I have nothing further to...
Thank you very much indeed.
Thank you.
Mr. Clayton.
My Lord, a few brief points, if I may. The first is, let me deal with the letter, first of all, which we've now got. If I may, with respect, make the point that Lord Comworth, repeat the point that Lord Comworth made. The last sentence on the first page is important, that the Fire Service examination therefore must be appointed by the Public Service Commission. That is precisely what did not happen in relation to the appellant. That's a simple point, but an important one. Dealing with a few issues of principle, my friend contended that the principle of Cooper had been overstretched. If we could just look at the judgment for a tick, page 109 at D, where it said there is no doubt that the constitutional principle would be breached if the body were used as an instrument which enabled the executive to interfere with the appointment of tenure. Well, as that rightly says, there's no doubt about that being a breach, but certainly the breach of the separation of powers goes far broader than that, and it's not a limit, in other words, it's not a limit on the principle, and indeed, like most constitutional principles, one has to approach it broadly and purposively, not narrowly and restrictively, which is, with respect, what the Court of Appeal did in this case. That, in a sense, touches on another point made by my friend, which is the breadth of the principle of separation of powers. And in our respectful submission, it's a broad approach, and clearly, if particularly in the Trinidadian context, with the importance of these service commissions being insulated from political control, if in effect that's imperiled, that's far short of direct executive interference, but is nevertheless unconstitutional. As to a few points made about the facility, the sort of exception identified by Lord Hope, a point I think made by Lord Wilson was the reason why there may have been a different approach in respect of past candidates and future candidates in 2006, as there may not have been any expertise at the relevant time. Of course, we have no evidence one way or the other about that, so that can't assist us in this case, in our submission. The second point I want to make is that as a matter of language, and I hate to be tetchy about it, but as a matter of language, the retrospective approval of a result is not the provision of a facility. The facility is a provision of a service, like providing examination systems. It is not ex post facto approving a decision. A fortiori, if I may so, when it's a decision made in accordance with Regulation 14, which on its face is unconstitutional because it breaches separation of powers because of the role of the minister under that process. So in our submission, the states or the respondents argue it must fail on the basis of suggesting that it's the use of a facility, both because it's not a facility at all as a matter of language, but in any event, it's the approval of a process which is unlawful from its very inception because it's Regulation 14.
Well, what do you say to the point that if your client had succeeded in the exams and had been expecting promotion and then been told he got to resit again because it wasn't valid,
He'd have been appalled.
Well, with respect,
He wouldn't have said, oh, that's quite unconstitutional. Of course he wouldn't. But maybe
well,
that's...
can we see what he says?
personally, I'm not so sure he would have been. He may have said all number of things, including to people who he was with, that it seems unconstitutional to him. His difficulty might be identifying a principle which would render it unconstitutional. It's not unconstitutional to rectify a process to address a constitutional.
Yes, I mean, the point I'm putting, I mean, the word facility is not a term of art, it's simply used by Lord Hope. And he says one's got to be sensible and practical in things. And the board those, indeed the writer of this affidavit, Mrs. Edward Joseph, faced in the end of, with the Cooper decision, had to decide what to do about it. And surely it would have been pretty odd to have said, well, you've got to redo these exams, and even if someone has passed and then fails, that's too bad. I mean,
well, with respect, in our submission, constitutional principles are to be applied. That's the first point to make. And the second is, although I appreciate the progress of things is quite slow in Trinidad, there is nevertheless a 15-month interval between the board giving its opinion, the sitting of an examination which proceeds on the basis that nothing's changed, and then a positive decision in December to adopt something which in our submission doesn't stand in the face of Cooper.
But Mr. Clayton, instead of the entirely hypothetical question that you've been assailed with, what if your client had passed, what about the actual question? What about all those who did pass in the 2006? They may still be in the fire service. Well, at their more senior positions.
They may well be.
And does it follow that their more senior positions are invalid?
No, it can't follow from that because there is first of all, we're not seeking an order which has the effect of quashing all the appointments. I mean, that's quite important to remember. I'm going to come on to the terms of a declaration in a minute, but we are not saying that everything that's happened has to be unscrambled. And it's partly important to remember that all legal proceedings are subject to time limits. And if the time limit is passed for saying things, then you can't get ex post facto relief from a court. So for the avoidance of doubt, we are not seeking an order from this court which has the effect of unscrambling everything that's been done in the face of it. What we are, however, saying is the approach taken, and important to remind oneself of the date sequence, which is 15 months after the board gives a judgment, and which, as we now know, now that we've had the benefit of seeing the letter, the original approach with respect was entirely right in the advice that Mr. Just took us to, but they decided to take a different course. And it's actually quite an important point to realize what they did. What they did was, well, we will change it for the future, but so far as everyone who's already done something, then they're stuck with it, even though we recognize, or we ought to recognize, that it doesn't pass constitutional scrutiny. And then in our submission, that cannot do. So what in our submission I would accept is that a declaration needs to be made. When Lord Conworth took us back to paragraph 32 to see although we haven't seen the final declaration made, what was actually fairly carefully.
What is it that you're asking us to declare?
Well, can I take you to it's page 21 of the bundle. This is the 5th round of relief. This is our best effort, and as my lordships will know, the terms of a declaration can often be improved by a court. So I'm not saying the council's got this bang on. But in any event, 21 says a declaration that it's the sole responsibility of the Commission to appoint the examination board referred to, and that Regulation 14 should be read and construed accordingly. Now, that's simply a proposal, but I want to make a submission about the importance of a declaratory relief in this case.
So you're asking for a declaration in the terms of paragraph 5. I mean, presumably that it was, not that it is.
Yes. I mean, I'm afraid, yes. And I'd say this is a proposed terms of the
Yes, but I want to get your submission. And,
no, I understand.
And it obviously has to be in the past, because it
Yes,
wouldn't be
that's
irrelevant.
quite right. My fault, entirely. But that's the declaration that I would, with respect, invite your lordships to make. And I want to make 2 separate points about that. First of all, the reason why a declaration should be made is we're here dealing with a constitutional breach, and an important breach, particularly in the Trinidadian context of separation of powers. And the second point, which I wanted to remind your lordships of, and I can't remember, this is my fault, which members of this board may have been party to the judgment of the Supreme Court in Hunt. But Hunt was a case where basically no relief was granted, and the Supreme Court made it quite clear that, normally speaking, in a judicial review case, a 40-hour constitutional case, if someone wins, then a declaration should normally be given unless there is some compelling reason to the contrary. And in our respectful submission, there is no compelling reason to the contrary.
Yes, I mean, you accept that it's a discretionary form of relief, but normally would follow the success.
Precisely so, my lord, precisely so. Can I just have a moment?
Yes, of course.
Yeah, and the point which Mr. Ramlow draws attention to is, of course, having legislation that lies on the books it doesn't preclude the possibility of being reused in the future, and at least a declaration would secure that result not occurring.
Yes.
My lords, unless there's anything else I can assist with.
Thank you very much indeed, Mr. Clayton.
Thank you very much.
I'm very grateful to Council.
I'm sorry, could I just ask you to just to clarify that this regulation is still on the books? Mr. Hughes, could you just confirm that the Fire Service Regulation 14 is still on the statute book?
I'm instructed it is, my lord.
But has not been used since 2006?
That's
Thank
correct.
you. And it's in the same form, though?
It remains in the same form, and it's
not been used.
dormant.
It's dormant.
Yeah.
Right, thank you.
Well, we're still grateful to Council for the concise submissions and to those who have been instrumental in preparing the written cases. The board will take time to consider their judgment. The court is now adjourned.